Greetings to examiners. My student ID is 200742248 and now I'm going to present my presentation on the topic of the possibility to attribute authorship of copyright works created with the aid of AI to a human being. Firstly, I shall discuss what is copyright and how it is related to AI. The primary objective of intellectual property law is to protect the rights of the creators of intellectual property. Copyright laws specifically aim to promote creativity and encourage authors, composers, artists, and designers to create original works by affording them the exclusive right to exploit such works for monetary gain for a limited period, and protect the creators of the original works from unauthorized reproduction or exploitation of those works. Artificial intelligence is a discipline of computer science that is aimed at developing machines and systems that can carry out tasks considered to require human intelligence, with limited or no human intervention. Technological advancements in the AI space have led to the creation of technologies and systems that can generate original content across various media. This has raised interesting questions as to ownership and infringement of AI-created content under copyright law. To serve as a case study, in 2019, OpenAI released the GPT-2, a language model trained on a curated dataset with the objective of predicting the next word on the basis of the preceding words within that text. Based on sentence input provided by the user and by adapting style and content, GPT-2 can create an entire news article or story that appears to be authorized by a human, which means that today AI can generate such random documentation by mapping and creating content at inhuman speeds. AI is now used to create local news articles or music albums, which is so sophisticated that an observer may not be able to distinguish between man-made and machine-generated content. While determination of the owner or author of a man-made work is usually fairly and straightforward, difficulties arise with respect to works created by AI. Copyright protection of work created by AI may be addressed in the following ways. First of all, states may altogether deny any copyright protection to works created by AI. Or states may attribute authorship of works created by AI to the AI itself. Or lastly, states may attribute authorship of works created by AI to the creators of the program. In most jurisdictions, only a natural person may be considered the author of a copyrightable work. For instance, the India case of Ripandra Kashyap vs. G1 Publishing House PVT Ltd in 1994, the court concluded that if any protection is sought to be provided to AI-created works, authorship must necessarily be attributed to a natural person. This also can be seen in Article 798 of Civil Code in Taiwan, which provides that the fruits generated by AI are considered community property and are not capable of copyright protection. By viewing AI as a tool of human creation, AI-generated works can be divided into two main categories. The first category is represented by works generated by AI programs with the direct guidelines, assistance, or input of human beings, which AI is used as a tool to achieve a determined or predicted goal or outcomes. An example can be seen in C.F. Bureau's Lithographic Co. vs. Saroni 1884. Here, U.S. courts first extended copyright protection to photography. They held that the camera used to capture the image was considered to be a tool which aided the author in creating an original work of art. This outcome, however, is still used as a legal precedent justifying the issuance of copyright to millions of photographs taken each day. Therefore, it could be argued that an AI machine, just like a camera, is simply a tool employed by an author to express his or her idea in a tangible form. The second category of work deals with autonomously generated AI creation. The computer programs responsible for autonomously generating words are the result of human ingenuity. Their source code may be copyrighted as a literary work. The artworks generated by such programs, however, are not copyrightable if not directly influenced by the human authors. In determining the authorship of AI in UK, it seems that the UK approach is to give authorship of copyrighted works created with the aid of AI to the programmer. According to Section 9 Sub 3 of the Copyright Designs and Patent Act, in the case of a literary, dramatic, musical, or artistic work which is a computer-generated, the author shall be taken to be the person whom arrangements necessary for the creation of the work are undertaken. Furthermore, Section 178 of the CDPA defines a computer-generated work as one that is generated by computer in circumstances such as there is no human author of the work. This idea behind such provision is to create an exception to all human authorship requirements by recognizing the work that goes into creating a program capable of generating works, even if the creation spark is undertaken by the machine. This leaves open the question of who the law would consider to be the person making the arrangement for the work to be generated. Should the law recognize the contribution of the programmer or the user of that program? In the English case of Nova Productions versus Mazuma Games 2007, the Court of Appeal had to decide on the authorship of a computer game, and it declared that a player input is not artistic in nature and he has contributed no skill or labor of an artistic kind. So, considering user action cases by cases could be one possible solution to the problem. There are three possible parties which may have claims to the copyright of AI-generated words: AI programmers, owners, and end users. When determining the best possible author, it is necessary to consider the overall social benefit. To better gauge the societal impact of each party, we must first determine the ultimate goal of assigning copyright of AI-generated work to human authors. Next, we can assess which party contributes most to this goal. Finally, we may deduce that the party which contributes most to the realization of this goal is best suited to possess authorship of AI-generated works. Providing financial incentives in order to encourage the growth and development of the AI industry and ensure the dissemination of AI-generated works is arguably the ultimate goal of assigning copyright to human authors. Since it is to promote innovation and creativity, it's ensured in copyright laws by offering a temporary monopoly. Financial incentives should therefore be reserved for the greatest contributors to the development and dissemination of AI due to the investment of time and skills by AI programmers and the financial backing of the companies for which they work. Also, since end users have the smallest contribution to the initial development of AI, their claims for authorship are least compelling. Providing incentive to AI programmers and owners would be the logical solution to ensuring sustainable growth and development of the AI sector. While independent programmers may retain copyright for the work generated by their AI, copyright of AI works created within large companies may be settled through employment contracts and attributed to either programmers or the companies for which they work. In conclusion, granting copyright to the person who made the operation of artificial intelligence possible seems to be the most sensible approach. With the UK model looking to the efficient, such an approach will ensure that companies keep investing in the technology, safe in the knowledge that they will get a return for all their investment.